the call from Zoom because otherwise it will stay live. And hello and welcome back to this afternoon of the TARGETjobs Virtual National Pupillage Fair, the first time that we have done this virtually. I hope everybody's had some lunch and that your laptops are well charged. We're about to talk about a different area of family law. We've covered family law in the past at the fair, and very often we look a lot at care cases and sort of various sort of topics like that. This year we have two speakers from QEB, that's Queen Elizabeth Building. We have Tim Amos, QC, who is the head of chambers, and it's very seldom that we have a head of chambers come to join us at the TARGETjobs Fair. And we have Thomas Haggie as well from QEB, and they're going to talk to us a little bit about life with the family bar and in the specialism of family law. So I'm going to hand over to Tim and Thomas now.
Hi there, welcome everybody. And as Matt says, it's perhaps unusual to have a head of chambers or one of the grey hairs taking part in the pupillage fair. The reason that we particularly are keen at QEB to take part in anything to do with the next generation recruitment to the profession is precisely because you are the future. And we are a self-employed profession where we are only as good as our last case and our next case, and you are definitely the next case. And so we invest a lot of time, energy, and our own money in bringing you on. And that's part of the reason that Tom and I are here today. You will find that he interrupts me quickly and often, and very welcomely from my point of view. But the purpose of our being here is to tell you about the commercial side of family law. And I say that deliberately because it's very easy to think that family law is all about care work and children and social workers. And although we do that in QEB, Queen Elizabeth Building, what we particularly specialize in and are known for is the other end of family law, which is the commercial side, the international side, the conflicts of law side, the corporate side of family law. And particularly if you are interested, you think even more in people than in numbers below a line on a company account, then this may be the area for you. And Tom and I intend to interest you enough in it this afternoon to make you ask the questions of yourselves, which might lead you to do what Tom and I each did a generation apart, which was to fall into family law by accident and very much against our first thoughts, because he'll tell you his own story. But in my case, I went ignorantly to a pupillage interview and they said, why do you want to do family law? And I said, I don't. And they said, why not? And completely ignorantly, you may think, I said, because I think the subject is dull and the people that do it are stupid. Well, if I was right then, you're about to meet two of the most stupid people around. 30 years later, I have learned that I was wrong. I learned that fortunately very quickly. And I have been fascinated ever since, because family law is where you make a huge difference to individual people's lives, where you have an infinite variety of cases, literally, because families come in absolutely all shapes and sizes and forms of diversity. And therefore, their lives touch every walk of law, whether it's landlord and tenant, whether it's company commercial, whether it is conflicts of laws between, for example, a Sharia divorce and an English divorce. What is going to take priority? What are the financial remedies that either party might have in those two conflicting cultural spheres, quite apart from the jurisdictional, geographical conflicts that we have between particular countries, particular jurisdictions? Is this divorce going to take place in Russia, as my case yesterday was about, or in London? Is it going to take place in the European Union or outside the European Union? What is the role of Brexit in all of that? Is Brexit a disaster from the point of view of family law? Never mind your political views. This is not about politics. This is absolutely about family law and the results, the implications of national and international legislation on families and on the rights of individual people. So where does that break down in terms of my law cases and your possible interest in family law? Well, if you've done any family law, or if you've done any other form of law, including company law, you may have come across the leading case of Prest, leading case in relation to the corporate veil and the circumstances in which you can pierce the corporate veil. That is a family law case. It's one that we took to the Supreme Court in 2013. And so I was in the Court of Appeal in 2012, the Supreme Court in 2013. It's sometimes said that that puts the law back into family law, because it re-emphasizes that family law is absolutely part of one law system, and that family law does not inhabit a desert island, as Lord Sumption said. We have to apply rigorously legal principles, one of those being that company law assets of company law, of companies, their assets are the company's assets. It doesn't mean that you can look through the corporate veil and say, well, this belongs to the managing director or the chief shareholder. So that's one of the areas that we deal with. Football stars, for another, is an area that we deal with, because they have a habit of producing children. And therefore you will read about them and their wives and girlfriends in the press, and we deal with their cases, whether for them or against them. Russian oligarchs, my case yesterday that I mentioned was one of them. And each of those cases is centered on a person, their particular problems, their particular life, and their particular circumstances. So including, as in my case yesterday, a party, in fact, the person wanting the divorce in England, is somebody who is very sick indeed, physically, in the very end stages of very aggressive cancer, and hopefully on the receiving end of some absolutely groundbreaking treatment in California that is not yet licensed in Europe, and certainly not in England, which is why the family has emigrated, firstly from Russia to London about 5-10 years ago, doesn't matter the exact date, and more recently to California in search of this very expensive but groundbreaking treatment that may or may not extend the life of the victim. But that's what I've been doing this week. I'm going to ask Tom to tell you from his point of view what he's been doing recently, to give you a flavour of the sort of work we do, and the particular point about family law, which is that very early on, as a barrister doing family law, you get very great responsibility and very great autonomy in your own cases, because it's you who stands between your client and whatever disaster is, in their view, befalling them at the moment. So it's from that point of view very creative, because usually when people come to us, the worst has either already happened or is about to happen. And our job, Tom's and mine and our colleagues, particularly may meet Andy Campbell and Sophie Clayton on the QEB stand this afternoon. Our job is to create something more positive for the future. And it's a broad canvas, and Tom is going to paint it for you in a little more detail. Over to you, Tom.
Thank you very much. Hello, everyone. I think the way, if I may, that I will give you my 10 minutes is, first of all, to tell you a bit about how I ended up being a family barrister, how I made the choice to go into this area. I'm going to tell you a little bit about why I think this area is interesting, particularly the financial side of the law. A couple of cases that I've done recently, which I can tell you about, which I hope makes you think this could be a really interesting thing for you to do with your career too. And then some very brief thoughts about what I think you need to succeed in this area of life, because it is a demanding one. A little bit like Tim, I didn't imagine myself, when I was a history undergraduate, becoming a family barrister. I discovered it actually at a TARGETjobs law fair, I think, where I remember quite vividly walking into Lincoln's Inn Hall, where the thing was being held, and thinking as I walked up the steps, I must remember not to talk to any of the family sets, because they're just going to be depressing, because they spend their whole life arguing about divorce and children, and that's not how I want to spend my life. And I wanted to talk to shipping barristers and stuff like that. Anyway, it all went wrong, because I ended up talking to some matrimonial counsel who were there, and they persuaded me, and I don't regret being persuaded. And what they said, and what is true, is that this is a brilliant area of life if you are a magpie, if you're curious about lots of different things, because a week can take you from arguing about the valuation of a company and being quite forensic and detailed in a actuarial manner, looking at that sort of stuff. You can end up the next day discussing pleadings of sham against the trust, which is the sort of thing that normally only Chancery Counsel would be looking at. And you can be doing quite complicated pleadings in equity, which you wouldn't otherwise be looking at. On the day after that, on the Wednesday, you could find yourself having basically an argument which is more comfortable in the criminal courts about domestic violence in a relationship, or indeed allegations of fraud in respect of in respect of someone's finances. And so if you are curious about lots of different things, family law is a great route into almost all of those areas that you could imagine doing. It's an area of life where you don't have to choose about how you want to spend your time, because all issues across the whole spectrum of law come up in these cases, and it does make it fascinating and it keeps you on your toes. In divorce money, which is what we do most of our time, there's two stages to a case. The first is computation, and the second is distribution. You first of all have to work out what's there for everyone, and then you have to argue about how to divvy it up between the husband and the wife and anyone else who ends up in the vortex of their divorce. Both stages are very interesting, and they present different challenges. The first computation stage can involve these complicated pleadings, as I've been discussing. You can be arguing about the valuation of a company. You can be attacking the purported integrity of a trust deed or defending it. You can be involved in a forensic analysis of bank statements to see what somebody's done with all the cash that used to be there, whether they're accurately representing their income, whether they're accurately representing the value of their business. And those are difficult challenges, and they're legally complicated, and they're analytically complicated just on their own facts, and it's a rewarding job. And often that is the most vicious part of the argument in court, is about that stage of computation. The second stage is distribution, where you have to decide what is fair to happen to all of this money. And that's an equally interesting challenge, and it's one that it's a canvas that is so broad. Many other areas of law will never let you talk in this way, because it is effectively an argument about what is fairness. The courts in this area are empowered to do more or less whatever they think is fair. The discretion is so broad. It is entirely open for counsel to do their best to persuade the judge in front of them that this is what fairness looks like. And the law changes at high speed in this area in a way that it doesn't do elsewhere. It was only 20 years ago that the courts decided that sharing of assets was the fair thing to do between a husband and wife, that there was no place for discrimination between the person who was keeping house and the person who was out earning the coins. We've had I'm trying to think, in recent times, we've had a lot of argument in the courts about how far something can be described as an asset that the couple have created together and falls within that principle, how far this idea of sharing should extend. We have constant arguments about how long somebody is dependent on a marriage for, insofar as their maintenance claims should extend into the future. All of these fundamentally rest on an argument about what a marriage is, what happens to two people when they choose to live their life together and they make commitments to each other and they have children together. How far we paternalistically as a society think they are bound for life together, how far that claim of fairness extends, how far we celebrate their autonomy. It's a canvas in which actually, it's a canvas with scope for bringing in ideas that might be more familiar to you from a sociology degree, or reading about feminism, or thinking about society at large. It's an area of law, but it's also a part of life, and it's a part of life which the idea of fairness is at stake, and that is a subject that brings in all sorts of complicated ideas about how we live as people. And the law changes so fast in this area. It's an exciting forum to be part of that conversation in, and that's what family barristers are arguing about the whole time. It might sound dry when you see it in the law report, but the stuff that they're talking about is fascinating. It goes to the very heart of who we are as people. So I think that's why it's interesting.
I'm going to jump in, if I may, there, Tom, because I want to pick up on your bonds of culture point, in the sense that different cultures view marriage differently, and there is often that collision. And so, for example, picking up on Tom's points about areas within family law, polygamy. Now, it's not something that the British society recognizes, at least in UK terms, and it's not something that English or Welsh law recognizes as a local law, but it's something that English law has to grapple with in relation to other societies which do recognize it. So that's one of the issues you have to think about. Legitimacy, obviously, not in terms of British society, where there is no difference in what used to be called legitimate and illegitimate, but in other societies, it makes a big difference. It makes a big difference from the point of view of inheritance, potentially. And from that point of view, we also have to grapple with paternity or filiation cases, in the sense that you can usually tell who somebody's mother is, but as we all know, it's sometimes difficult to tell who the father is. And usually people go where the money is. So you have all sorts of cases that flow from that.
I think all of that's right. And one of the fascinating challenges of the area is that the case in the High Court, which make the headlines, make the law, tend to be between very, very wealthy people who are often very, very international families. That, you know, Russians, Arabs, wealthy Africans and Americans who come to England to live or to have their divorce, and they are in a jurisdiction which has been created by quite deep and a particularly English set of thoughts about what fairness means, about life between a husband and wife. It starts from the idea in England of a nuclear family and a husband and wife who hold responsibilities to each other and who should share with each other. But the families who come to this jurisdiction and who make the law might have profoundly different cultural views on who is responsible for a wife, for example, at the end of a marriage, whether it is right that the assets that you make together should be shared. They may come from much more patriarchal societies than the one they find themselves litigating in. And the tension between the people involved and the quality of the law is an interesting feature of the jurisdiction, at least I think.
I agree with that, because if you go back to Tom's initial categorization in money cases between first stage computation, working out what there is, and second stage distribution, how do you split it? Clearly, the first stage is more mathematical, but it's also more forensic in the sense that you have to find the money if you are the applicant, and you have to explain it if you are the respondent, in a way that may be seeking to distance your own client from that money. Hence the arguments, for example, in the Prest case about whether you can or cannot look through the corporate veil to say, well, actually, really, this is the asset of, in that case, the husband. And I can say that because it's a publicly reported case. And you will know, if you've studied it, that Mr. Prest was saying these assets are all held by the companies. The companies are nothing to do with me. And the lower courts and the Court of Appeal found, as a matter of fact, that the husband's presentation in that respect was correct. And the question of law was whether you could then look through it. And the way the Supreme Court dealt with it was to say, well, we're going to undo all of those facts, and we're going to find that actually the husband never successfully alienated ownership from himself when he transferred the assets into the companies, and therefore the companies were holding them on resulting trust for the husband. So again, that is where it's a very legal and rigorous jurisdiction. Whether you are trying to bust a trust if you are for an applicant, or defend a trust if you are for the trustees who've been dragged into an argument between, say, wife and husband as to whether the assets of a trust are genuinely held independently, or whether it's really all a piggy bank for one or other of the spouses. But in that context, let me turn particularly to Halina Kholod's question in relation to the Russian example that I gave, but I emphasize it could be any language example, any culture example at all. But Halina's question is, does it help as a barrister if you spoke Russian as well? Well, certainly in that case, it would undoubtedly help if you speak Russian. And there are lots of Russian English cases, particularly at the moment. As you, Helena, probably will know even better than most if you speak Russian. But undoubtedly, languages in this area help. Whether it is French, Russian, Hindustani, any language that you think of, we have in QEB a wide range of languages that we collectively speak professionally and are able to work in. But language is not absolutely essential. What is absolutely essential is the intellectual rigor to analyze the situation, both in terms of the law and the human soft skill of being able to deal with people at what is almost by definition from their point of view, cataclysmically difficult time in their life. And so you need to be able to bring those interpersonal skills absolutely to the fore, whether you call it bedside manner, soft skills, whatever you call it, you need to have them. And that is why, in terms of the commercial law end, this is the field for those people who are perhaps thinking about commercial law and thinking, well, I'm jolly clever and I'm interested in numbers and figures and finance, and therefore commercial law is the obvious end for me. And I would simply say, stop and pause and think, well, actually, might I not be able to get the same commercial, legalistic satisfaction, and above all, international satisfaction out of family law, the commercial end of family law? And on top of that, I would get the people interest in family law, which comes with any sort of family law at all.
I think that's right. It's an area where pragmatism and getting someone on your side quite quickly are both really important. Tim mostly does very glamorous cases because he's such a doyen of the bar now. But I don't do mostly glamorous cases.
Well,
I do some glamorous
cases.
used
Fiver will be in the post, and I'll love him in the morning.
Most of my time, or certainly in my first couple of years when I was in chambers, a lot of what I did was work for people who didn't have a great deal of money and were in a real pickle because they simply, every pound they spent on their litigation was a pound that was going to make it less likely that they could have a house or be comfortable in retirement or meet their grocery bills each month. And the feelings run incredibly high. People can be appallingly stressed, uncertain about the future. They are in the context of separating from a marriage they might have been in for many, many years, and they're often feeling profoundly hurt, worried about their children. And you're dropped into this situation, really having received the papers about it all, perhaps yesterday. And you have to turn up, and you've been paid by this individual probably more than they've paid for any professional service before in their life. And you have to, if you can be somebody who can get into that situation and can work with that person very quickly and can do your best to broker a arrangement for them, a compromise with the other party, represent their interests as best as you can. That is a great skill, and it's an area of law where settlement is often the outcome, and often the right outcome for a client. But it can often be very difficult to see how to get there for somebody because there's a huge penumbra of issues in any given case at once. And if you can be pragmatic about these things, can take someone with you, can cut a good deal for them, and if a deal can't be done, fight for them as hard as possible. It's an area where you can really make an impact on someone's life. It's satisfying on a good day at work to have gone into a county court in the middle of nowhere, met someone who has spent 2 years, probably more, worrying about this situation, not knowing how to get out of it, not knowing what's going to happen to them, and sort things out, roll up your sleeves and sort things out. So by the time you leave the court at 4 or 5 o'clock, their life is now on track and they kind of can understand how it's going to play and what's going to happen to them. And they've stopped hemorrhaging money to their solicitors and they've stopped having to worry about what their future is going to look like. And you've sorted that, and you can sort of pat yourself on the back for that for that outcome for someone. So even at the junior end, before you start arguing about trust structures in Jersey, or however you might spend the full glory days of your career, it can be really rewarding at the lower end as well, because you can make a real difference to people's lives, and they can be really grateful for it. You know, you've solved a problem that they had, which they couldn't fix by themselves, and that's very satisfying. At least I find it satisfying.
They still come back years later, it's worth saying, because frequently you will be sorting their life at the stage when they have a small child or some small children, and you'll be sorting their life in some dramatic, from their point of view, dramatic way, whether it's enabling them to go and live abroad or securing their financial future here at home if they live in England, as Tom suggests. But because the children are perhaps young, and there will be future arguments between the parties about child finance or child issues, what's to happen to this child or that child in particular circumstances, the case keeps coming back, or I should say, the client keeps writing to you from time to time saying, actually, what you did for me way back when little Johnny was very small is still really making a big difference to my life, and I'm still really grateful. And that's one of the other aspects of family law, that, as Tom says, we do a lot of negotiation, a lot of settlement, but still, because the nature of the argument means that tempers do run high, as Tom says, an awful lot of cases still end up in court. And even though we settle a lot of those cases even at the doors of the court, still there will be arguments that are before the judge, like the case that I did on Thursday, where we were arguing about whether the same judge, Thursday's judge, had been mistaken when he made the orders in 2014-15. Those were the orders that he made settling the finances. And in that case, my side were saying, well, you got it absolutely right, judge. But the other side were saying, no, judge, we were all mistaken back in 2014, 2015. Look, we can show you transferred the wrong bit of land, and the result now is that the husband's able to build on that land and make a lot of money, and it's unfair. And we, for the husband, were arguing against that. So even where you have very high-level negotiations, they very often don't succeed. And the point about that is that as a family law barrister, you get more than average experience and flying time in court. And therefore you build up more quickly the experience as an advocate that your purely commercial colleagues may actually not get in years, because they may only go into court once a year, whereas Tom will be in court several times a week. And winning, I hasten to say, on every single occasion. Every day in Tom's life is a good day. But it also takes us on to Kristin Ferragati's question. How you become a family barrister. Now that, Kristin, is absolutely the right question to be asking. And I won't waste your time with the views of somebody who became a family law barrister now 30 plus years ago, by mistake, as I say, instead of which I'm going to throw it back to Tom, who became a family law barrister much more recently, but still by mistake.
It's a good question. I'm sure everyone listening will know the technical requirements to apply to the bar, which is that you have to have done a law degree or the GDL conversion, and then you have to do the bar professional training course. I think that if you want to become a family barrister, it's worth thinking purposively about the sort of skills you will need, especially in the early years of your career. I think it's important to recognize that what we're looking for are people who can be quite pragmatic about things, can look practically at a question as well as abstractly. Somebody who's got the intellectual interest and curiosity to think about law, to talk about it. Because as I say, this is an area of life where you will be a legal magpie and you'll come across lots of different legal theories, and somebody with the intellectual curiosity to deal with those things is someone that we're looking for. I think that if you can, I don't want to give anyone sort of particular career advice, because there's so many different routes to the same to the same target, doing some mini pupilages is inevitably a helpful thing, especially when they work, especially when they start working again once coronavirus eases up a bit. I think it's good to have reflection on why you want to do this job in particular, why you don't want to go and be a care barrister or a criminal barrister or a commercial barrister, because those are all things that we touch on the edge on in what we do here, but why you want to do this thing in particular. And so it's worth not just going off to One King's Bench Walk and the other good chambers who do this work. It's worth also going to try and look at some of the good chancery sets and some of the good crime sets and the care set, and look at what they do and really think for yourself as to why this particular life is one that is for you. It's an unusual combination of being quite technical and legalistic, but also quite frequently in court. I go to court 3 or 4 times a week, most weeks. All of those cases tend to raise a point which I have to look up, or many of them have to raise a point that I have to look up and think about. And you have to do it at quite high speed. So you have to enjoy going to court, you have to enjoy negotiating, and you have to enjoy picking briefs up quickly. And so if you want to spend 1 year doing a massive case which may never go to trial, this is not the area for you. You have to be comfortable with working at quite high speed, and you have to want to go to court, and you have to want to settle things. So we're looking for somebody who is pragmatic, somebody who's curious, somebody who's quite resilient, I think, to what is basically quite a high-paced and stressful job. Somebody who's got a good human touch, who can get people on their side quite quickly, and someone who's thought really carefully about why it's us you're after, not Wilberforce doing chancery law, or Raymond Buildings doing crime. It's a peculiar form of life that we have, and we want to know why you want to do it in particular. And I think if you can think of it like that, that is the broadest advice I can give. There's many roads to Rome. So if you're volunteering in a FRU centre, if you're working in some citizens advice bureau, if you've done none of that, but you've written an interesting dissertation which has got you interested in the area, all of that's fine. I can't tell you between those things which is the best. What I can tell you is what we're looking for and what we want to see, which is somebody who's really thought carefully about why this is the life that they want, I think is what I'd say to that.
I agree with all of that. And indeed, it takes us into Tom Huxmar's question. History of negotiation with clients in crisis, mostly at risk of losing their tenancies in housing options, will be beneficial to applicants for pupillage in matrimonial cases? ? Well, the short answer, Tom, is yes, it will be. But in saying yes, it will be, it emphasizes that is exactly the type, but by no means the only thing that will be helpful to an application for pupillage in matrimonial sets. Anything which you have done or seen or thought about which has involved dealing with somebody in a crisis situation, and which has required of you to think about what is the actual nature of the problem, whether it's landlord beating them up or whatever it is, and what are the legal and practical, really important to emphasize Tom's point about practical, pragmatic solutions. What are the practical implications of that? And what is the best way for this individual person for me to be able to help them forwards? Now, all of that will apply, as Tom Haggie says, to a whole range of things that many aspiring new recruits to the profession will have done, whether paid or unpaid, as a student or otherwise. And each of those can be turned to real advantage, to your real advantage in an application for pupillage to a family set of chambers. But I absolutely agree with Tom. Have a look at other sets, other walks of life to see what you do and don't like.
Yeah, I mean, it is ultimately, it's your future we're talking about. And so you need to think about it really carefully. And the most attractive applicants we get are the ones who've really reflected on why this is the life that they want. Because I think that's good advice. Whichever part of law you're going into, think really hard about why this is the one for you, and we'll be interested to hear that as well, as it will help you.
And that will mean you've done it better than Tom Haggie and I did in getting the wrong area. And that was because we perhaps hadn't investigated it as early and as closely. I hasten to say that Tom Haggie was much better able to adjust earlier than I was. But then by the time he came along, everything was more specialized. And by the time you all now are coming along, it is so much more specialized that you really do need to know what it is you don't want to do for a better reason than I thought I had all those years ago.
What I would say is we don't expect you, when you arrive as a tenant or when you arrive as an interviewee, to be a tenant or a pupil, sorry. We don't expect you to know family law inside out and to have read every one of or to have read all of the cases, or indeed to know much about it. When I came for an interview, I really didn't know a lot about it at all, and I learned on the job. And I don't know why they gave me a pupillage. I'm glad they did, but the question that I was posed in the pupillage interview was quite a long problem, which had all sorts of things going on in it. It was a kind of case study. I was invited to work through it with the panel, and I got through it and I came up with some good things, because I tried to think about it as practically as possible and to try and keep the children front and center in my analysis of what was going to happen with all of the money and the house and everything else, and how it might work for these people and what they might be concerned about in any deal that they would come to or any situation that might arise from it. And I think that having that sort of quite pragmatic approach from the very start served me well. And then I got through the door, and then I was able to learn more about matrimonial law on the job, really. So I think it doesn't hugely matter what your particular experience is, what your background is, what particular things you've been doing. What we would like to see is why they lead you to think you might be good at our job. And whether that's dealing with people in crisis, whether you might have had a relation who's had some difficulty in their life, or you've had to help look after, and you've had to deal with their stressful situation, or you might have worked in a centre or volunteered with vulnerable people. You might have been in business and have been used to cutting deals and used to negotiating hard. I don't know, but whatever it is, try and think how that helps you come to be a good candidate for a job which involves you dealing with people the whole time, being in court a lot, negotiating a lot, and trying to solve difficult situations for people at fairly high speed, whilst retaining an interest in law and legal procedure and everything else. And I think if you think purposively about your experience, which will be as many and various as however many of you there are sitting watching this webinar, that is your best way forward in framing your applications, in my opinion.
And you'll see from our website, it's up there just behind me, the QEB website, QEB for Queen Elizabeth Building. You'll see that contains really quite a lot of information specifically about the pupillage process and what we offer, what we suggest, and how the pupillage process works, and how the work of a family law barrister works, and something of our history and something of our future. And from that, you'll be able to gauge something of the ethos and whether it suits you, but particularly the type of work. And so I would urge you to have a look at that. And in the final minute, let me just reassure you that we, whether it's Tom and I or other members of QEB, are available to answer your questions, whether today or another day. Particularly our two colleagues, Andy Campbell and Sophie Clayton, are manning the virtual stand at today's event. And so I would encourage you to go to the QEB stand for that, talk to Andy Campbell and Sophie Clayton, but also, as I say, have a look at our website. And beyond that, keep an open mind. I did not have an open mind. Fortunately, Tom's mind was opened earlier than mine, and I remember his interview. You do not need to have studied family law. What you do need to do is, as Tom says, to have an open mind, a practical mind, and an analytical mind mixed with an interest in people, because that's what family law is, front and center, first and last. So I hope that is helpful, Matt. I'm conscious that we have hit our 2:10 exactly. I hope that's good for you. And any more questions, we're delighted to take, whether now or offline.
That's absolutely brilliant. There was no way I was going to interrupt the flow of two master family barristers as part of this webinar. Thank you very much for fielding everybody's questions. I have had a couple more come in, and I really would urge you, as Tim says, please do take them over to the QEB stand and speak to the barristers there. I just want to say thank you very much. Please put, all of you who are watching this, thank yous in the chat as well to Tim and to Tom for taking the time to tell us about absolutely fascinating area of law. We really, really do appreciate you taking part in the Talks program.
Pleasure. Nice to see you again, Matt. Thanks.
Nice to see you too.
Bye all.
Bye.
Thank
Bye.
you very much.